皆さんこんばんは。
So once again, good evening.
リーガルイノベーション入門観光記念イベントを
And here we are to celebrate the launch of our book, Legal Innovation, Introduction to Legal Innovation. And we are very happy that we are holding this event. About 120 people, as of yesterday, have applied to listen in, and we are really happy. And this is going to be a 60-minute program, and we look forward to what we will hear. Now, first, I'd like to explain the program for today. So we have 60 minutes, but first, I would like to introduce the hosts and guests. And we will first talk a little bit about the book itself. And representing the readers, we will have Mr. Osaki for some comments. And then we have 30 minutes for panel discussions. And finally, we will have a closing. So that's the agenda. So it's just 60 minutes, but I believe we have a very rich program. So I do hope to have your cooperation in holding this session. Now, first, to introduce the hosts of this event, I am from the Graduate School of Law of Hitotsubashi University. I'm Mihoko Sumida, and we have the Associate Professor Felix Steffek from the University of Cambridge, Faculty of Law. So first, I'd like to introduce Dr. Felix Steffek.
Felix Steffek 先生は、ケンブリッジ大学
So he is the associate professor of the Faculty of Law at the University of Cambridge, and he's also a member of the Newham College. And Dr. Steffek has received a J.M. Keynes Fellowship in Financial Economics by the University of Cambridge. And for this event, he is the co-host, and also he serves as the co-director of the Center for Corporate and Commercial Law, or 3CL. And he covers corporate law, insolvency law, commercial law, and dispute resolution, and of course, the main theme of today's event, technology and law. So those are the areas that he covers in his research. And the book actually came out of a research project between the two universities on artificial intelligence and legal systems, and he is a team leader of the research project. So I'd like to ask Dr. Steffek to introduce me, the other host.
Yes, thank you very much, Mihoko. That's a great pleasure. And so introducing you, Professor Mihoko Sumida is a professor in civil law at the Hitotsubashi University Graduate School of Law. Her research areas are contract and tort law. Her involvement in the trial of a stock exchange system failure, and that happened in 2005, led her to work on the challenges that the technology poses to legal systems and theory. She is, on the Japanese side, the principal investigator from on the research project, Legal Systems and Artificial Intelligence, conducted at the University of Cambridge and also by Hitotsubashi University. The aim of this research project is to explore the impact and implications of the introduction of AI into the legal system. Mihoko, back to you.
Yes. それでは次に、野村総合研究所の大崎貞勝先生。
And next, I would like to introduce Mr. Sadakazu Osaki. So he graduated the University of Tokyo, and then in 1986 he went to Nomura Institute, and he also went to Edinburgh University, Europe Research Institute, and also he attended London University as well. His area of research or expertise is securities regulation and corporate law. And also he has been involved in the revising laws related to securities transaction. And so now, Dr. Steffek, if you can please introduce the next speaker.
Yes, and here it is a great pleasure introducing Professor Simon Deakin. Simon Deakin is a professor of law at the University of Cambridge. He specializes in labor law, private law, company law, and EU law. And he contributes regularly to the fields of law and economics, law and development, and empirical legal studies. He is director of the Center for Business Research and a fellow of Peterhouse. He has held visiting appointments at Columbia University, the European University Institute, and Doshisha University in Kyoto, in Kyoto. He was elected to a fellowship of the British Academy in 2005, and he is a recipient of the ECGI and Alan Overy Prize for Corporate Governance Research. He is the principal investigator on the UK side of the project on legal systems and artificial intelligence.
Hello. Now, 東京工業大学の山田先生。
Next, I'd like to introduce Professor Hiroaki Yamada. He graduated from Waseda University and then went on to study natural language processing and calculative language processing at the Tokyo Institute of Technology. And in 2022, April, he has become an associate professor there. And theory mining and also automatic abstract creation of law documents or legal documents is his area of expertise. And his research actually was carried out alongside our research project. Now, I'd like to ask Dr. Steffek to introduce Mr. Ludwig Bull.
Yes, and finally, it's a great pleasure introducing Ludwig Bull. He is the founder and CEO of CourtCorrect, a successful law tech startup. Ludwig has studied law at the University of Cambridge, where he organized the first ever competition between legal AI and commercial lawyers. In addition to law, he also took courses in coding, which has put him in the ideal position to found other law tech startups before founding CourtCorrect in 2019. Ludwig has very kindly prepared a video, which we will see now, Mihoko. Ludwig, I think, Mihoko, you wanted to say a few words on the book?
Yes. それでは次の
Okay, then. Moving on to the next item, which is about the book. I am one of the editors. I would like to explain a little bit about how the book came about. So I believe the audience of this webinar are familiar with the word innovation. However, when you stick innovation with legal, probably you are wondering what this all means. For the young generation, especially those who want to become lawyers, who want to seek legal professions, are probably more perplexed by the combination of the words legal and innovation. However, of course, the law is an infrastructure of the society and economy. And if you are going to re-establish that, I believe if you do not have an innovative orientation, you will not be able to lead the society toward a better way. And therefore, we had this sense of urgency, a sense of crisis, and that's why we carried out a certain experiment. And actually, that led to the book Legal Innovation. It was actually started as an online class. And I would like to introduce a little episode here. In 1966, in March, in Wisconsin, there is this high school called Rice Lake High School, and Thomas J. Ritzinger was actually a physics teacher, and he contacted a world-renowned physicist who received the Nobel Prize in Physics in 1965, Richard P. Feynman, and he was proposing a certain experiment. And that was about using a long-distance telephone line by way of an appointment call to have the Nobel laureate speak to his students. So that was the request that Ritzinger made. And Feynman thought that this experiment, which cost a lot back then, was amazing. And he thought that this was a very good idea. And concerning the lecture, he was asked to speak for about 35 to 40 minutes. However, it turned into a Q&A session between the students and Feynman. And Dr. Steffek and myself, we have been involved in a project concerning law and AI. But we wanted to speak with the students to start having new ideas. And we also carried out an experiment of this online class. So it's been about 50 years since Feynman's telephone lecture. But now, in the half a century, technology became really advanced. Back then, it was one telephone line, but our online class was where we had about 20 guest speakers come along, and we were able to have a very enjoyable class. So technology, of course, is different from the past and present, but I thought that there is one thing in common here, and that is that this was an event that would remain in the students' memory for their lifetime. That's what we wanted to provide to our students as well, and we are very happy that we were able to hold this very exciting class online. And now that we launched this book, I hope that more people will be able to share the fun that we had in class. Now, so Felix, please.
Yes, thank you, Mihoko. I would like to say a few words on legal innovators, because that is one of the main themes of the book. And I would like to start with a question to you. Who do you think was the greatest legal innovator ever? I like this question because it requires us to define legal innovation. We also need to identify the types of legal innovation that we value. And also we need to look at the long list of people who have contributed to the law over the centuries. I've asked some of my friends what they think. And the first reaction of all of them was, that is a really difficult question. And I think that answer is already part of the answer overall. Yes, it is difficult to identify role models for legal innovation. And I have come up with 3 reasons why it is so difficult. First, legal innovations have to be evaluated against the background of their times. Second, legal innovators are operating and benefiting from a network of other innovators. And third, the definition of legal innovation plays a major role. Now, taking these issues in turn, legal innovation happened at all times and against the background of the then current state of the art. Some might point to Johannes Gutenberg, introducing movable type printing in 1439, starting the printing revolution that transformed the way law was made and communicated. Today, almost 600 years later, the paper Gutenberg imprinted on is losing significance as law becomes more and more digitized. It is difficult to compare the relevance of printing law and the impact of digitizing law as the significance is rooted in time. Second, legal innovators do not operate in a vacuum, as interaction and communication are essential features of law. For legal innovators, perhaps even more than their contemporaries, learn from others. Aristotle, a strong candidate for the list of most impactful legal innovators, is a good example. While Aristotle's contribution to justice theory was a major step into uncharted territory, his ethics built on the thoughts of Plato, his teacher. And third, the question arises what legal innovation is and what legal innovators contribute to it. Perhaps some of you were surprised to hear that I mentioned Gutenberg and Aristotle to be included in a discussion of legal innovators in the first place. An argument not to include them might be that they are ultimately not lawyers, but a printer and a philosopher. Instead, one could point to legal innovators who contributed to legal doctrine, such as Nobushige Hosumi, a law professor co-drafting Japan's civil code at the end of the 19th century, and developing legal doctrines covering technologies such as the telephone. Or one could focus on the legal profession instead, and point to the innovation of law reports or the virtual law office. Lawmakers at national, international, and transnational level are also strong candidates for a list of outstanding legal innovators. The last consideration I'd like to raise is whether legal innovation can be measured, perhaps by counting the number of applications of an innovation or the value that is generated. Measuring legal innovation certainly raises the issue of what we value in legal innovation. And is it then just change that matters, or only change that made people's lives better? With this, I'd like to end and hand over to Mr. Osaki of the Nomura Research Institute, who will comment on the book that we've published.
Thank you very much. I'm from the Nomura Research Institute. My name is Sadakazu Osaki. As one reader who read the book, I would like to give my impressions. And as Dr. Steffek just said, legal innovation, this concept is quite wide. However, when I saw this title, the book title, Legal Innovation, I thought that technological advancement is going to contribute to legal resolutions or to help lawyers. I thought that it was a book about how to use AI for legal disputes. That's what I imagined by looking at the title. However, when I read the book, it covered a very wide area, just as Dr. Steffek has introduced to us. And it was a good read. And especially at the beginning, it talks about the tsunami damage lawsuit at the Okawa Elementary School. The children of the elementary school died in the tsunami, and there is this lawsuit for damage, claiming damage. And there is no AI use in this, and there is no computer use in this. It's a legal case that has no connection to technology. However, it talks about the parents of the children who wanted to give a good impression to the judge. They sent letters to the judge in order to appeal their feelings about losing their child in the tsunami. So it's quite an emotional case. Rather than utilizing technology, there are a lot of episodes like this, but However, the way the lawsuit was pursued showcased legal innovation, and this gave me a very strong impression. So, if you are changing the way you solve a problem that was not easily solved in the traditional way, and also if you are going to create a legal framework to provide relief to the victims and give them opportunities for relief. I believe that is what legal innovation is all about, and I truly agree to this way of thinking. After reading the book and by rethinking legal innovation, I thought that there are some challenges that needs to be looked into toward the future. The first one is, well, when we think about a new framework, innovation and also creating law does seem like they're talking about the same thing. So things that should be resolved by law and things that should be resolved through innovation. How do you distinguish between the two? Or are they different? Or should we just disregard any difference between the two? I think that's something we need to look into. Secondly, and I believe that this will be picked up in the panel discussion, but legal innovation will probably lower the hurdle for legal access. Of course, if you use AI, maybe you don't have to go through this legal process and you will be able to resolve disputes. And that's a good thing. But if disputes are resolved in this way, cases that reach the court will be drastically reduced. And all the cases and the knowledge that have been accumulated in the past will no longer be visible to the public. And of course, the AI will make predictions for dispute resolution, and that in itself may be innovation. But if we rely too much on AI, are we not hampering further innovation? Maybe we need to think about that as well. And thirdly and lastly, we are now connected between Japan, UK. We don't feel as if we are so far apart as we discuss. And because we are able to do this, maybe for dispute resolution as well, we don't need to physically be in the same place for the resolution. We may not have to go to the same court together. Actually, some lawyers here in Japan are utilizing online processes, and therefore some lawyers will say they handled 5 cases in a day. But if that happens, yes, it's more effective, it's lower cost, and that is good for many stakeholders, and resolutions will be provided to many people. And maybe the parties involved will be able to choose how they want to resolve the problem. But of course, the jurisdictions that were in place in the past may lose their capability or ability to provide legal resolutions. People may not want to go to court at all. So that may be a very important point to consider as well. So those were the impressions I had as I read the book. Thank you very much.
Thank you very much. So earlier on, before going to the panel discussion, we were unable to share the video. So Ludwig's video, let's share it now.
Minasan, konnichiwa. Watashi wa Rudo de gozaimasu. I'm the founder and CEO of Court Correct. Court Correct is a legal AI company based in London. We're a team of engineers, designers, and legal experts helping businesses and governments address one of the biggest problems of our time: access to justice. And what a great time to do this. Around the world, legal systems are reaching a breaking point. In Britain, the time it takes to get your case through court has reached a 100-year high. In India, the courts have a backlog of 47 million cases. And even in Japan, citizens are avoiding courts because of high costs, delays, and complicated processes. That's why we're developing AI systems to make the resolution of civil disputes user-friendly and scalable. But how do we do that? First, we scrape a huge amount of legal data from various public and private sources. We've already scraped millions of records. Second, we train AI models to understand the data and make predictions. You can even talk to some of our models. Third, we embed that model into a beautiful UX. That's it. Given our interest in this field, it was a great honor to be invited to contribute a chapter to legal innovation. As part of our collaboration with Hitotsubashi University, and as the conversation about legal technology begins in Japan, I would like to suggest 3 things corporations and governments can do to bring innovation in this field to Japan. 1, start pilot projects with startups to test things and learn. 2, make as much legal data as possible available to the public. And 3, provide a regulatory sandbox where new solutions can be tested. Thank you so much, and see you in the panel.
Very happy that it can finally proceed. So, shall we proceed the program to the next?
Yes, let's do that, Mihoko. Thank you.
Yes.
So we'll now have a panel discussion. First on technology and dispute resolution. And then later, Mihoko Sumida will moderate the second panel. So this panel is on technology and dispute resolution. For this panel, when we discuss the term dispute resolution, I suggest a wider understanding, covering negotiation, mediation, conciliation, ombud schemes, arbitration, and court proceedings. I would also like to invite the audience to submit questions using the Q&A function. And I would like to summarize or kind of focus my question to the panelists in one question. And that is, from your perspective, what advantages do you see for the use of advanced technologies? For example, AI, distributed ledgers, or other advanced information and communication technology for the management and solution of disputes? And also, after thinking about the advantages, what do you think are the risks of using such technologies in dispute resolution? If I could please first invite Professor Deakin to share his thoughts with us.
Oh, thank you very much, Felix. Thank you, Mihoko. I'm just going to share the screen for a second because I've got a slide which I hope I can show. Let me see if I can make this work. Actually, at the moment, I'm not able to see the relevant slide, but maybe I can show it later on if it's possible to do so. Actually, it doesn't really relate to this theme. I was going to say something about legal evolution, but I think this is a slightly different theme. Let me say that the whole question of how law innovates is an interesting one. I've been working in this field for a long time, and I worked with economists and technologists looking at the way in which innovation occurred in society. And when I say to people, the law also produces innovation, most of the time they're very skeptical about this proposition. So I'm delighted that this book has appeared to confirm the reality of legal innovation and legal evolution. Law is a system for retaining information and making progress possible, but it's a social institution, not fundamentally governed by material laws which determine engineering and physics and other disciplines. So what we see here with legal technology is an interesting encounter between an engineering-based logic and a social or human science, which is legal science or legal reasoning. So this is an exciting moment. And as Felix said, potentially very important, given that law, as we understand it, is based upon written texts, and a particular technology, the printing press, has produced modern positive law and the law of the nation state. And as we move to a digital age, we can only expect fundamental changes in the nature of the state and the nature of law as a consequence of this shift, the nature of which is very difficult to foresee. In terms of dispute resolution, going forward, the critical question, it appears to me, is to what extent it's possible to use machine learning, which is a technique involving particular mathematical forms of reasoning and engineering hardware, to replicate a social process, legal reasoning, which is not so far dependent upon these techniques or modes of organization. So theorists of law and technologists must at some point encounter the question, to what extent is legal reasoning, which depends upon natural language, consistent with or different from the types of mathematical representation which are used in machine learning? And this is a profound question which relates to legal theory and also to philosophy. Do we think of mathematics itself as a language and as a mode of representation? And if not, is it instead a direct encounter with a material reality to which law must adjust? That seems to me to be a critical issue. Natural language, I think we would all agree, is a mode of representation and doesn't fully reflect material reality. What then is mathematics? So I put that question on the table. In terms of the implications for dispute resolution, I'd like to refer back to what Professor Osaki said earlier. Legal evolution depends critically upon production of a large amount of case law from which efficient rules more or less might be expected to emerge, or at least stable rules. This is what the theory of legal evolution teaches us. And if that supply of rich case law is to be maintained in the face of automation, some basic questions need to be asked about how in future we will generate legal evolution in a very different world in which decisions are henceforth automated. Are we not in danger of cutting off the supply of cases upon which legal evolution depends? But of course, I remind myself at this point that the purpose of legal decision-making is dispute resolution and delivery of justice to litigants. That's the first and foremost objective. As Ludwig reminded us, there are issues here about access to justice. And the production of rules, which are of course a public good, which benefit everybody, is a byproduct of the delivery of justice in individual cases. So I just put those questions on the table without pretending to have the answer to them. But I think these are issues we might all wish to discuss, not just today, but going forward. Thank you.
Thank you very much, Simon. Mr. Osaki, may I turn to you and ask, what do you think can technology contribute positively to dispute resolution, but what are possible risks? You've already mentioned access to justice, but also risks to access to justice.
ありがとうございます。2つの問いをいただ
There are two questions that we have received, but I will intentionally, regarding the positive aspects, I don't think we need to touch on those because we all know. Technology being utilized is in principle full of good things. It's a good thing. And there are lots of merits, benefits, and I'll leave it at that. And regarding the risks, earlier on, I'd like to add to what I said earlier on. One thing is, for example, technology itself it has inherent risks. And when you think about legal issues, in such situations, we don't have to be that sensitive, I think. For example, there's automated driving, or there are financial transactions, and there are high-level technologies being used. For example, if an AI runs wild, out of control, and with automated driving there's an accident, or in financial transactions there's unexpected losses, people talk about that. It's true, these are major risks. But regarding legal issues, my understanding is that, for example, if you leave dispute resolution to an AI, the conclusion that you get, or the results that you get, if it's not correct, however way you look at it, then human beings will correct it. I think that's the basic premise. So the technology is only to help human beings, and human beings will make the final decision. I think that's the positioning of technology. So technology running wild regarding legal innovation is something I think we do not need to worry about. And from a completely different perspective, something that concerns me is the existing law systems inside. There are certain things that will probably be an obstacle to technology. For example, in Japan right now, there's the law regarding lawyers, and in Britain too, I think there's something similar. So lawyers receive money and they give legal advice, and only lawyers are allowed to do that. And if an AI checks the contents of a contract, does it not violate this law regarding attorneys or lawyers? In other words, an AI is not a lawyer, or the person who develops AI is not a lawyer either. That's probably the reasoning. Or the company that provides the AI is not a legal entity. Maybe that's the reasoning. So if you apply these old ways of thinking, then you can impede innovation. So the existing systems and the new facts or the new technologies, is there not some kind of conflict? And checking this, I think, is very important.
Thank you very much, Mr. Osaki. Now, Ludwig, I'd be interested in your opinion. You've already, of course, in your video set the ground for your thoughts on the advantages and the risks of using technology for dispute resolution, but we are, of course, interested to hear more.
Yeah, absolutely. Thank you, Felix. So maybe I can start with the advantages. And I think the clear advantage is around access to justice. And, some of the statistics I mentioned in the video, there are many more statistics from other countries. This really is a big problem, and it's a problem that is actually getting worse in a lot of countries. So we need solutions for access to justice. And there has to be some degree of technological assistance or automation in order to actually satisfy the demands of the public when it comes to using the legal system. Otherwise, they will just solve their disputes in different ways, and we're already seeing that happen. I want to pick up specifically on one of the potential risks identified by Mr. Osaki and Professor Deakin, which is around the production of fresh case law. I think this is a very interesting point, and I think you're absolutely right. We need to develop case law, and judges need to continue hearing and deciding difficult cases. But what we do not need is judges spending their time on thousands of flight compensation claims, for example. And this is the reality of what judges are doing. Judges are spending a huge amount of time on cases that could be decided in a simpler way or even in a semi-automatic way. And in some countries, this leads to the totally, bad effect of judges sometimes spending only 90 seconds to make decisions on convictions in minor offenses, as has happened in the UK. So I think really the role of technology here is to ensure that the right cases are the ones that judges are spending their time on, the difficult cases, the cases that actually develop the law. In terms of risks that I see, the main risk that I see is a lack of reasoning, lack of explainable decision-making. If it's true that we're going to need some degree of automation or semi-automation to actually satisfy the demands of access to justice through AI systems, then those systems have to be explainable. And, currently a lot of them are not. So the final point I want to make is also related to Professor Deakin's, I think, a little bit deeper lying sort of question around law and artificial intelligence, and whether these two domains actually can meet. And I think this is a more fundamental question that's sort of running along the parallel of the nature of language versus the nature of mathematics. So I think, the main question is it even possible to show these social processes with, mathematical instruments like machine learning? Currently, probably the outcome is unknown. We don't fully know yet. But if you look at some of the most advanced machine learning models or AI models in natural language understanding, like GPT-3 or some of these internal tools that were leaked from Google this year, the conversational AI and the progress that is being made in that area is very significant. So this is not specific to law, but it is specific to language. And we're seeing a very rapid development of AI technologies that do seem to understand certain linguistic concepts. So basically what we're doing is we're applying that technology specifically to law. And also the progress that we've made at Court Correct in just a few years has also been such that I'm confident that we will be able to deliver real value to the public and to the justice system. So yeah, but I think, again, one of the main things that we're currently concerned with is also making sure that we have explainability of these systems, because that is a prerequisite for them actually being accepted and used successfully in the public.
Thank you very much, Ludwig, for sharing this. And now to conclude this part of the panel, Dr. Yamada, I'd be interested in your opinion.
Yes, I hope you can hear me. Yes, we do. And yes, we have heard a lot of very interesting points, some challenges that we may face ahead. But Dr. Deakin, Professor Deakin, the current machine learning and the automated model, how far have we come with this? Actually, how do we create or assess these models? The assessment criteria is also very difficult, and also this is a very important point. The most simplest way to put the question is which side won the case, the plaintiff or the defendant. If we had a model to judge that, and if a layperson who doesn't have any knowledge of law, would that be helpful? I think there's a big question mark here. And as Ludwig said, explanation. If there is an explanation behind the reasoning of reaching a certain conclusion, if the user can understand that, then it would be something that is useful. Therefore, explanation, providing the evidence of reaching a judgment or a decision is very important. And let's say, for example, we are able to gain explanation. But with AI currently, most of them use deep learning or machine learning. That's the technology that is being used. And that's what's behind AI. And that's put all into a black box. I believe you all have heard about this. Simply put, we don't know what's going on inside that black box. And so then how do we interpret what's happening inside the black box? Or let's put that aside, and are we able to gain an explanation? Are we going to add something so that we can gain an explanation after the decision? But with the machine learning model, if it is quite accurate, is it going to surpass human mind? I don't think that's so. Rather than interpreting the model, human beings will be linking the evidence as well as the decisions made by judges. I believe that's the way these tools should be used. That's all for myself.
Thank you.
So then, thank you very much. Let's move on to the second agenda for this panel discussion. The next one is about establishing an ecosystem for legal innovation. What is it that we should do? So let us pick up this question. Right now in Japan, we often talk about establishing a startup ecosystem. We are discussing how to establish such an ecosystem. But what we want to pick up here is about establishing a legal innovation ecosystem. And Dr. Yamada has explained a little bit about his research, but for legal innovation ecosystem, from a researcher's viewpoint, what are you doing and what kind of contributions do you think you can make, or what are the challenges you are facing? If you can very briefly explain that. Yes, I would like to share my slide here. I think you can share your slide now. Do you see this? So my research and also my project with Professor Sumida is providing some legal issue for resolution by the machine to get an output. But rather than talking about that, I would like to talk about things around that. How are we able to carry out such a research? So what kind of model is more accurate, or what is the actual accuracy or precision? I believe that's what people are interested in. But if we try to carry out such an experiment, defining the task, how do we define that task? The decisions made by human beings and also the negotiations or the arbitration, and it's a very complex job, but how do you formalize that so that a machine can actually use that? And also the basis for the decision, how do you explain that? So these, that's the fundamental question that I have. However, the experimental infrastructure, we don't have a lot of data sets. And in order to make the data sets, we need to go through annotation to documents. But how do we do that? What is the best way to do that? Especially here in Japan, we don't have examples that we could follow. And also, even if we do have data sets, the natural language expressions, will computers be able to process that? Can they be coded? We need to have these encoders so that the language can be turned into codes. Japanese and English, the coding encoders are made for each different language. And also some focus on certain domains like science, technology. But do we have something that focuses on law? No, we didn't. And so we are trying to establish that infrastructure that is necessary. So what kind of annotation is necessary? We are speaking to lawyers and also law students so that we can come up with a good annotation method. And then after establishing that, the Japanese tort case dataset, we are using this. We are actually looking at actual cases. And also I said that there is no encoder, but we are trying to create an encoder for the judicial area. And Ludwig said in the video, but here in Japan, we don't have data, therefore we want data to be available to the public. But especially only a limited number of cases, the decisions are open to the public. And also the legal records are actually very difficult to get, the records of lawsuits. But if we can improve these environments, we believe that we can do something. But in the past several years, We have this movement toward more open data, and therefore we are hoping that we can see legal innovation where technology and the legal sector comes together.
ありがとうございます。
Thank you. In that case, next, in order to expand our image, Professor Simon Deakin, regarding new legal theory, from your perspective regarding legal innovation, regarding this ecosystem from academia, to make this more rich and bountiful, what kind of ideas can you suggest to us? Could you please introduce your ideas to us?
Yes, thank you very much. I'm just attempting again a screen share. Let me see if I can make this work this
Yes.
time. Just trying to find the relevant slide. It's not very easy this morning. For some reason, I'm having difficulty with the technology. I know I shouldn't do. It should be a lot easier than this. Let me see if I can make it work now. Hang on.
I think it works.
It should work. There we go. Okay. Okay. So this is my slide. Now, I've been doing research on legal evolution for some time, and this is the idea that the legal system is an information resource which has evolutionary properties. So it's complex and non-ergodic, and to some degree has features in common with natural systems and also with social systems which evolve. And natural language is used to code information about social objects, including technological ones. And what we're now seeing, I think, with automation of law is perhaps a perfectly natural consequence of changes in technology. The Industrial Revolution itself was about automation of the production of material things. And we're now at the point where we can automate language and produce judgments. We're automating a wider range of things through binary coding. The original looms of the Industrial Revolution used primitive forms of computers. Computing technology has improved over time. Machine learning is a kind of evolutionary algorithm which involves a type of error correction involving the adjustments of weights over time in a way that's, in a sense, spontaneous, but of course has to be designed by a human being. Now, what is the implication of this? I don't think there's any purpose in imagining that legal automation will not take place. It absolutely will, because many other features of social life have been automated over the past 2 centuries. And we know from industrialization that automation improves access, absolutely. So where we can manufacture high quality goods, the silk goods, which were once only available to the emperor in his palace in Kyoto, are now available to everybody thanks to automation. And mass production replaces the artisan, who now only produces for a few people. Of course, we need people to use machines. Few machines are completely self-organizing. And the lawyers of the future will be using AI in the way that the looms of the past had to be tended and machined, looked after by real people. So we may see a shift in the legal function, but we're not likely to see the disappearance of the human person. And human judgment will remain critical to the use of machines in this area, as with others. But of course, going forward, we have fundamental questions to answer about the nature of machine learning in the context of legal automation. I am skeptical about the possibility that we'll ever completely understand the processes which are involved in deep learning processes, because by definition, human beings can't compute at the same scale that machines can. What we can understand is what machine learning is. Machine learning is a way of crystallizing the past, recording it, and aligning it with future expectations. And what we should be thinking about is how far law is like that and how far it is not. Machine learning is a particular type of evolutionary algorithm, which in my opinion can very well explain the long run evolution of law, because law also involves an evolutionary algorithm. But I am not sure that machine learning should be used to decide the instant case, because I suspect that it's not capable of the type of forward-looking approach which human language and human reasoning permits to lawyers. Now, that, of course, is a proposition I can't defend in 3 minutes, but we may be able to discuss now and in the future. Thank you.
ありがとうございました。
Thank you very much. And I know that our time is up, but we do have a question from the floor, and therefore I'd like to go to Osaki-san to comment on the characteristic of the Japanese society and also answer this question. And this is the question that we received in Japan. Some people die after getting mochi, sticky rice cake, stuck in their throat, and also konjac jelly, which is more elastic than traditional jelly. There were people who get that stuck and choked on it and died. And some people say that this is unacceptable and that this should be punished. So is there, it seems that there is some thing about the Japanese law that maybe there's something funny here. So that's the question that we've received. So Osaki-san, please.
Thank you. So regarding this question, I was looking at the question and I was thinking that the legal innovation ecosystem building, so this points out an extremely important issue in our doing so. In other words, my understanding is that this konjac jelly, why is it a problem? Because it's new, that's why. In the past, it was only natural that there were certain accidents, but there are different kinds of accidents happening. So they're similar accidents, but a completely new experience. So there is extra terror. For example, with automated driving, I feel the same kind of thing. So if an automated driving car causes an accident, this does happen in the experimental stage, but clearly, an ordinary car, if someone who's drunk drives it and causes an accident, people are more shocked by an automated driving car causing an accident. But in terms of the damage caused to society, the accidents caused by traditional cars are probably causing much more damage than the automated driving. So something new causes a problem. When that happens, people are unable to correctly assess the risk. They tend to overestimate the risk. I think there's that kind of tendency. And I think this is not just something that we have in Japan. So regarding this, in the future, regarding legal innovation and utilization of technology, I think this could be an impediment. For example, using AI, the people concerned will mediate and reach a settlement, but the result from a third-party expert may seem very unjust. And when there's a case like that, they say, because you use an AI, that's why we had this unjust result. And this is an impediment to providing relief to people who are disadvantaged. That's something that I'm worried about, people saying things like that. And earlier on, Ludwig was saying in the video towards the end, I think that's very important. So in the existing framework, something innovative. So for legal dispute resolution, when we put something in, then a legal sandbox is necessary. So we try it out in terms of thinking, and if it doesn't work, at some point in time, we should strengthen the restrictions. But regarding things that might not be allowed by regulations, we should first start out by allowing it. I think that stance is important. And with konjac jelly, because there was one accident, we should not ban konjac jelly, this traditional mochi, but in a true sense of the word, which has higher risk? We need to cool-headedly evaluate this. We need to make sure we spend sufficient time to do this. That's what I felt.
Thank you very much. And already we are over time, but Ludwig, listening to all the discussions, I believe you are leading a startup that is really leading the way for innovation. So for the ecosystem, in order to establish an ecosystem, what do you think is most important? So if we can have your comment, please.
Yeah, sure. So I think I think the first thing to realize is that actually building an innovative company, especially if it's developing a new technology, a new product in a new field, is something very difficult to do.
Yes.
And most companies fail trying to do that. So this is, I think, what you have to have as the backdrop when you're thinking about how to encourage innovation. I think generally things that are needed to build companies is in this space. So definitely, as Dr. Yamada said, access to data, very important. And I think when it comes to court data and data about legal rules, there's a very good reason for it to be public, because these are the rules that govern our lives. So we should be able to find out what they are. Secondly, of course, access to capital is very important. I mean, it takes money to build a company. And I think thirdly, the most important thing is perhaps a certain mindset about how to go about these things. You know, you have to understand that the outcome is uncertain, that there might be changes, that there might be challenges that have to be overcome, but really the process of successfully building a useful product that helps move society forward is a process of working through all of those issues and all of those challenges. And that is a mindset that needs to be shared amongst a sufficiently large group of people that also can contribute capital, can contribute data, can contribute expertise. And if all of these things come together and you're lucky, you will end up with a great product that actually helps people.
ありがとうございます。
Thank you. I think we have run out of time, and we would like to end, but lastly, Felix, could we have a few words from yourself, please, to close?
Yes, of course. I was really intrigued by what we heard. And I think all I can say, I think, Mihoko, you know, I think we need to engage in another project because there's so much more to be discussed. And
Yes.
I'd like to close with that.
ちょっと時間のマネジメントがうまくいきませんで、視聴者
I
の皆
apologize. My time management was not really good. I apologize to everyone who joined us. But I think we had a very active discussion, and we were able to propose some questions. And it was very stimulating to our imagination, I think. It was a good time. And our research project still continues. So I do hope that little by little, we too can evolve. And I hope you will stay with us and watch over us. Okay, with this, we would like to end today's event. Thank you very much for taking part. Thank you.